6 gun rules that every state in this country has been enforcing against you. Gun not weakened, not challenged, declared unconstitutional and illegal. On May 8, 2025, the United States Supreme Court, in a stunning ruling, confirmed what Second Amendment attorneys have been arguing for years: 6 specific regulatory requirements that states and cities have been using to restrict your access to firearms. Every single one of them violates the Constitution. This affects every gun owner in America, every concealed carry holder, every person who has ever tried to buy a firearm and hit a wall they couldn't explain. This ruling affects you whether you live in Texas or California, whether you're a first-time buyer or a 30-year veteran gun owner. And here's what makes this different from everything you've heard before. Turn on CNN right now. Turn on MSNBC. You know what you won't hear? A clear, plain English breakdown of what this ruling actually means for your daily life as a gun owner. What you will hear is either silence or spin designed to make you think nothing important happened. That's not an accident. That's a choice. Cable news serves an audience that doesn't want you informed about your Second Amendment rights. They want you confused. Confused people don't exercise their rights. This channel was built for people who actually take their rights seriously. Hit subscribe and prove it right now. Because in the next few minutes, I'm going to show you 3 things most gun owners will never know. Number 1, exactly which 6 rules were struck down and what they were doing to you. Number 2, which states are now scrambling to rewrite their laws before gun owners figure out what happened. And number 3, a specific, actionable plan you can follow starting tonight to protect and exercise your newly confirmed rights. Stay with me. This one matters. Let's lay the foundation so you actually understand what we're talking about. The ruling we're covering today builds on 3 landmark decisions you need to have locked in your memory. First District of Columbia v. Heller, 2008. The Supreme Court ruled 5-4 that the Second Amendment protects an individual's right to keep and bear arms, independent of any malicious service. That was the foundation, the constitutional bedrock. Second McDonald v. City of Chicago, 2010. The court ruled 5-4 that Heller didn't just apply to federal jurisdictions, it applied to every state and every city in America. Illinois thought they were safe. Chicago thought they were exempt. The court said no. Third, and most importantly for today, New York State Rifle and Pistol Association v. Bruen, 2022. This one changed the entire legal test for gun regulations. The court ruled 6-3. Justice Thomas wrote the majority opinion. The new standard: if a gun law doesn't have a historical analog from the founding era of this country, it fails, period. That ruling was a seismic shift, and states have been fighting it ever since. Which brings us to May 2025. The specific mechanisms from the May ruling and the constitutional principles underlying it flow directly from Bruen's historical framework. Lower federal courts applying the Bruen test have been systematically striking down regulatory schemes that states have relied on for decades. The 6 categories of restriction we're covering today represent the regulatory architecture that courts applying Bruen have found constitutionally indefensible. Quick disclaimer before we go further, and I mean this seriously. This video is educational information only. It is not legal advice. Every individual situation is different. Always consult a qualified firearms attorney for guidance specific to your circumstances and your state. That said, understanding your rights is the first step to protecting them. So let's keep going. The Bruen ruling 6-3 was the gun control lobby's worst nightmare, but the May 2025 applications of that standard, those are the follow-through punch they never saw coming. Here's exactly what fell. So let's go through each one. I'll tell you what the rule was, what it was doing to you, and exactly what its removal means for your life. Point number 1, discretionary may issue permitting schemes. Under these systems, still operating in states like New York, New Jersey, Maryland, and Massachusetts, a government official had the power to simply decide whether you deserved a permit. Not based on law, based on their personal judgment. It's like needing a neighbor's permission to enter your own house. You own the house, you have the deed, but someone else gets to decide if you're worthy of walking through the door. Courts applying Bruen have made clear, if you meet the objective legal requirements, the government does not get to say no based on discretion. That subjective gatekeeping is constitutionally dead. Point number 2, overly broad good cause and justifiable need requirements. New Jersey called it justifiable need. California called it good cause. Maryland had its own version. The concept was the same. Prove to the government that you have a special reason to carry a firearm. Not just your constitutional right, but a special reason, Courts have now confirmed your Second Amendment right is the reason you don't owe the government an essay explaining why you want to exercise a constitutional right. Hit the like button right now. It tells me to keep making videos like this, and drop a comment below telling me which of these 6 surprises you the most. Point number 3, mandatory government-approved training before exercise of rights. Now, I want to be careful here because people misunderstand this. Voluntary training, outstanding. I recommend it. Responsible gun ownership includes knowing how to operate your firearms safely, but mandatory government-defined training as a prerequisite to exercising a constitutional right, that's a different animal entirely. It's like requiring someone to pass a government speech class before they're allowed to speak at a public meeting. The right exists before the class. The class cannot be the gate. Courts have found that training mandates structured as permit prerequisites, particularly when combined with fees and waiting periods, constitute unconstitutional infringement. Point number 4, excessive fees and financial barriers to permitting. In some jurisdictions, the cost of obtaining a permit between applications, fingerprinting, training requirements, and renewal fees ran into the hundreds of dollars. The courts have begun recognizing what this really is, a poll tax on a constitutional right. Poor Americans have constitutional rights too. Your ability to pay a government fee cannot determine whether you get to exercise the Second Amendment. But here's the part that most channels completely skip, and it's the part that matters most to you, personally. Point number 5, waiting periods structured as absolute prohibitions. Not all waiting periods are treated equally under the new standard. What courts have targeted are waiting period schemes that function as flat prohibitions, particularly in situations involving immediate personal safety needs. When a domestic violence survivor needs protection tonight, a 14-day waiting period is not a cooling-off period. It's a death sentence dressed up in bureaucratic language. Courts applying Bruen have scrutinized these structures and found that absolute waiting periods without emergency exception provisions fail constitutional muster. Point number 6, vague and overbroad prohibited places designations. States like California, Illinois, and New York had designated so many locations as gun-free zones that lawful carry became practically impossible in any urban environment. When virtually every public space is a prohibited zone, the right to carry outside the home becomes theoretical, not real. Courts have confirmed the government cannot hollow out a constitutional right by simply labeling everywhere a sensitive location. Not every state feels this equally. Let me break it down for you clearly. Group 1, most affected states. And these are the states where the legal landscape has changed most dramatically. If your state is on this list, you need to pay close attention to what I say next. California may issue permitting, strict good cause requirements, some of the highest permitting fees in the country, and an ever-expanding list of prohibited locations. Every single one of those pillars is now under direct constitutional pressure. New York, ground zero. New York was the defendant in Bruen. The state legislature passed the Concealed Carry Improvement Act immediately after Bruen and trying to rebuild the same walls under new names. Courts have been dismantling that structure piece by piece. New Jersey justifiable need was New Jersey's signature restriction. Gone. The state is now in active legal litigation, trying to figure out what it can still enforce. Maryland, similar discretionary permitting structure, similar result. Maryland gun owners are waking up to rights they've never been able to exercise in their lifetimes. Group 2, moderately affected states. These states had some restrictive elements, but not the full architecture of the most affected group. Massachusetts, Connecticut, Hawaii, and Illinois all fall into this category. Illinois is interesting because Chicago specifically had constructed a regulatory environment so hostile to lawful carry that court challenges are ongoing at multiple levels simultaneously. Massachusetts has a licensing structure with subjective elements that are now constitutionally suspect. Group 3, minimally affected states. Texas, Florida, Arizona, Tennessee, and most of the South and Mountain West already had relatively permissive regimes. These states moved toward constitutional carry in recent years, and that alignment with Second Amendment standards means they're largely unaffected by these rulings. If you live in these states, your rights were already better protected, but pay attention anyway, because your state government is watching what happens elsewhere, and some will be tempted to adopt restrictions that are now clearly unconstitutional. All right, I've been watching the comments in the forums, and there's a lot of misinformation circulating right now. Let me clear up the top 4 myths before they cost someone their rights. Myth number 1, This ruling means anyone can carry anywhere with no restrictions whatsoever. Here's the truth that is completely false and dangerously wrong. The rulings we're discussing struck down specific types of unconstitutional restrictions. Courts have consistently upheld genuine sensitive collation designations, government buildings, schools, courthouses. What was struck down were overbroad designations. There is a significant legal difference. Know it. Myth number 2, if the Supreme Court ruled 6-3, red states already had these rights and this doesn't change anything. Here's the truth. This is backwards. The value of these rulings is precisely that they apply everywhere, including the blue states where gun owners have been treated as second-class citizens for decades. A 6-3 ruling from the Supreme Court is not a suggestion. It is the law of the land in California as much as it is in Texas. Myth number 3, my state just hasn't updated its laws yet, so I still have to follow the old rules. Here's the truth. This is legally complicated and potentially dangerous to assume in either direction. An unconstitutional law that is still on the books and is still being enforced by police who may not have updated guidance. Do not use a YouTube video, including this one, as your legal authorization to disregard a state statute. That's what firearms attorneys are for. Get qualified legal advice before acting on any changed legal landscape in your state. Myth number 4, the gun control lobby is just going to accept this and move on. Here's the truth. This may be the most dangerous myth of all. The same organizations that push these laws in the first place are right now working on the next generation of restrictions, designed specifically to survive the Bruen test. They are not done. They are regrouping. And now that we've cleared that up, here's the part that keeps me up at night. I need you to understand something about how this works. When the Supreme Court strikes down a gun law 6-3, states don't just accept it and move on. They hire lawyers, smart lawyers. And those lawyers start looking for every possible workaround. Here's what they're already doing. And I mean right now, tonight, the rename and relaunch strategy. California didn't get rid of its permitting structure after Bruen. They renamed it, restructured it, added new language designed to look objective while maintaining the same practical effect. New York did the same thing with the Concealed Carry Improvement Act. They called it a response to Bruen. It was actually an attempt to rebuild the exact walls the court had just knocked down, just with different window dressing. Expect to see this pattern repeat aggressively in California, New York, New Jersey, Massachusetts, and Illinois. The eligibility certificate play. Some states are drafting legislation that would require gun owners to obtain what they're calling eligibility certificates, or firearms identification cards, framed not as a permit to carry, but as a prerequisite to even purchase. It's the same restriction, different name, same effect. The sensitive location expansion. Watch for states to dramatically expand what qualifies as a sensitive location, not through broad general language that courts have already rejected, but through highly specific designations that individually sound reasonable but collectively cover every inch of public space. If they can't ban carry broadly, they'll ban it specifically everywhere until the right only exists in your living room. The financial attrition strategy. Fees requirements, databases, mandatory insurance, these are coming. The goal is to make the exercise of your rights expensive enough that the average person simply gives up. Right now, tonight, someone is drafting legislation to bring these restrictions back under a new name. I guarantee it. Subscribe and turn on the notification bell right now. I will track every single state response to these rulings. The moment a new bill drops, the moment a court issues a new decision, you will be the first to know. Don't let them rebuild these walls while you're not watching. Host is energized, empowering tone. This section should feel like a coach at halftime. B-roll, person at computer, person at gun store, person with attorney. You now have more power than before. Use it correctly. Here is your specific action plan, starting tonight. Step 1, know your current legal status in your state. Go to your state attorney general's website tonight. Look up your state's current concealed carry and firearms laws. Know exactly what is and is not currently being enforced, even if that enforcement may be unconstitutional. Knowing the gap between what the Constitution says and what your state is still trying to enforce is how you protect yourself. Step 2, consult a qualified firearms attorney. I'm serious about this one. A 1-hour consultation with a Second Amendment attorney in your state could be the most valuable hour you spend this year. Laws are changing fast. You need someone who knows your specific state's current posture, not just the federal constitutional standard. Step 3, document everything. If you are denied a permit, denied a purchase, or subjected to any restriction you believe is unconstitutional, document it in writing. Get the name of the official, Get the reason in writing if possible. That documentation is the foundation of a legal challenge. Don't lose it. Step 4, know your reciprocity. If you have a carry permit, verify its current reciprocity status with every state you travel through. The legal landscape is shifting quickly and reciprocity agreements can change. Check before you travel, not after. Step 5, support active litigation. Organizations like the Second Amendment Foundation, Firearms Policy Coalition, and state-level Second Amendment groups are actively litigating these exact issues in courts right now. Your support, financial or otherwise, funds the legal battles that produce the rulings we're talking about today. Step 6, contact your state legislators. Particularly if you're in a most affected state, your legislators need to hear from you. Not angry messages. Specific, informed, constitutional arguments. Elected officials pay attention to constituents who clearly know what they're talking about. Step 7, share this video. I mean this practically, not just as a content request. Most gun owners, have no idea what just happened. Sharing accurate information is how we protect each other. Let's land this plane. So 3 things I need you to walk away knowing. Takeaway 1, 6 specific categories of gun regulation: discretionary permitting, good cause requirements, punitive training prerequisites, excessive fees, absolute waiting periods. And overbroad prohibited zones have been found constitutionally indefensible under the Bruen standard. These aren't close calls. These are structural violations of your rights. Takeaway 2, the states most affected, California, New York, New Jersey, Maryland, Massachusetts, Illinois, are not going to comply quietly. They are actively working to rebuild these restrictions. Your vigilance is not optional. Takeaway 3, you have a legal and constitutional framework on your side that is stronger right now than at any point since the founding era. But a right unexercised and undefended is a right eventually lost. Here's a historical context I want to leave you with. Heller in 2008 said the right exists. McDonald in 2010 said it applies everywhere. And Bruen in 2022 decided 6-3 gave us the legal test that changed everything. And the rulings flowing from that 6-3 standard are the follow-through that Bruen promised. This is the most consequential period for Second Amendment rights since the founding. That is not hyperbole. That is where we are. With that right comes responsibility. Know your laws, train regularly, carry safely, be the kind of gun owner who makes the Second Amendment impossible to argue against. Now drop a comment right now telling me which of those 6 rules surprised you most. I read every single one. Share this video with every gun owner you know. Most of them have no idea this just happened. Change that tonight. Subscribe if you haven't already, because next week we're breaking down exactly how California is trying to rebuild its permit system and why their new approach may already be unconstitutional before a single law is passed. I'm not done watching, and neither should you be.